So here we are, a little bit about myself. I've been an attorney since 1989. I do estate planning. I work in healthcare with seniors. I work, that has been my forte over the years since 1989. I work with seniors that have homes up north that come down here. I have had the good fortune to travel with the State Department and be a resource for them in different countries throughout the world, and worked in healthcare systems, working on their legal and their healthcare issues for their seniors. I represented the United States at the European Union in Budapest, Hungary, and I think that was 2011, at a summit of nations. So I've seen what other nations are doing and brought some of these ideas to the table for everyone else to share. So with that background, with that knowledge, what I've developed is sort of a talk where when I have a Snowbird talk, I know basically there's going to be two fundamental issues. The first issue I'm not going to talk much about because I brought a handout. And that is for the folks that want to know, how do I set up my domicile in Florida? Because I don't want New York and New Jersey to tax the crap out of me. There are certain things that you can do. And as an attorney, I have to say, I'm not giving you legal advice because I can't unless you're my client. This is for informational purposes. So I have a document up here that has a laundry list of things that you can do, which we won't take the time because there are other important things that I want to talk about that I see that other people like to talk about in these seminars. If you would like that laundry list of things that you can do to establish residency down here so that you can contest with your government up there, and particularly in the Northeast. Although we're seeing it more and more around the country now, but the Northeast is horrible when we come to talk about estate taxes and inheritance taxes. These are the things you can do. Okay, so now we're going to talk about the second part, which is what people like to talk about. And these are going to be essential documents that everybody should have, that you may have up north, and then you'll have questions about down here with those documents. You may not have the documents, and if you do, I would encourage you to think very hard about getting these documents. So the first set of documents are called powers of attorney. How many people have powers of attorney? Okay. How many people have them here in Florida? Okay. So we have here, there are two types of powers of attorney. There's one that is a power of attorney, and usually it's for a particular purpose for a stated period of time. There's another thing called a durable power of attorney, and it is durable, which means if you become incapacitated through an accident, you're in the hospital, maybe you get Alzheimer's or something else and you don't have capacity, you have a durable power of attorney, which goes through that incapacity and can continue to work. This is so important, which I've seen time and time again, particularly with the elder population, because if, let's just say, your spouse becomes incapacitated and she does not have a power of attorney, if she needs to at any time apply for government benefits, if she at any time needs to transfer part of the homestead, which you share together under Florida law, you can't do it unless you have a power of attorney. So people come into my office, and what is the next step if you don't have this durable power of attorney? The next step is you have to go through a very costly proceeding called a guardianship. When you go into court and you have doctors come in and you have to put your spouse through this, and an evaluation is made whether or not they have capacity. And then the judge appoints whoever the judge thinks that you should have. That's the first thing when it comes to powers of attorney. The second thing that I see a lot with powers of attorney, we'll say the same situation, and I have somebody that comes down from out of state, and they have a power of attorney, and the spouse becomes incapacitated. They are now here in Florida, and they come to me because they've run into a problem with the power of attorney, because it doesn't comply with Florida requirements. So in Florida, we had a major overhaul of the power of attorney laws. And there are certain things called superpowers, which we have, that have to be in the powers of attorney in Florida. These include things like making trust, amending trust, applying for government benefits. It goes on and on and on. If these things are not in the power of attorney, the courts often will not recognize. And more than often, if you try and take that power of attorney to a financial institution in Florida, the financial institution won't honor it. So if you have powers of attorney from up north, and you may have been told, well, if it was created in another jurisdiction and it's valid in the other jurisdiction, it should be valid in Florida. As a general rule, it is, but that doesn't mean that the bank's going to honor it, and it doesn't mean that it's going to be good for every single purpose, such as applying for government benefits. Is everybody with me so far? Do we have any questions about that?
What was the legal process if you do not have a durable power of attorney?
It's a good question. So that's called a guardianship.
Okay, thank you.
So you go through this whole process where you have to go to court, and a ward is appointed to represent the person. That's another document you should have. In Florida, we call it a pre-need guardian designation. A pre-need guardian designation, you designate in advance, in the event that I would become incapacitated, I want my sister Sue to be the guardian. And under Florida law, the judge looks at that first. So now, if you had to have that situation, if you were in that dire strait, then you have already designated what you want in advance, and you're not leaving it up to some strange judge to make that decision for you.
So does that paper have to be notarized?
Yes. It has to be, that paper has to be notarized and has to have 2 witnesses. So there is, and if you look at other jurisdictions, some don't have those same requirements. Okay. Yes.
And for everyone's information, the shipping post down the road by Publix, they have a notary and can do your witness thing. So just for that. My question is, we have a living trust in another state with our will and power of attorney and all that, but we're snowbirds, so we're down here for 5 months. What document do we need, or what do we need to have that valid when we're down here? Do we have to meet with an attorney down here, get like a document?
So really, I'm going to ask you to, I'll give you the short answer. And then we're going to talk about wills and trusts in the next section.
Okay.
But yeah, you should have an attorney review that.
Review that document.
Right,
See if
right.
we
And
need it.
when I talk about the wills and trusts, I might answer some of those questions to that. And if I don't, hit me again and we'll do it again. Okay, so that's the first, those 2 documents there, power of attorney and the pre-need guardian. Then there is the healthcare surrogate. The healthcare surrogate. So the healthcare surrogate is a document where you designate in advance who you would want to make medical decisions for you, who could set up caregiving, who could meet with doctors, who could get your medical documentation, and do all these types of things like an attorney for you, only for healthcare. Okay?
Is that different from a medical power of attorney then?
So a lot of times it's referred, excellent question, a lot of times that is referred to as a medical power of attorney. So it's a medical power of attorney or a healthcare surrogate.
Okay.
No, and that's a good question too, so let's hit that one. So the living will is, just like it says, it's a will while you're alive, where you're not saying, I want Ted here to be my healthcare surrogate to make decisions for me. You're saying in the living will, if I'm ever in a persistent vegetative state, if I'm ever unconscious and hooked up to the machines, this is my desire. That's called a living will. And I recommend everybody have one of those as well. The Florida Bar has the form for that. If you were to go out and Google it, you could see that. Attorneys could draft it for you, but that is one that the Florida Bar has a form for that. So again, the difference is in the healthcare surrogate, you're saying, I want this person to make the healthcare decisions for me. And in the living will, you're saying, these are my decisions, I'm making them in advance. If it ever happens to me, this is what I want to happen. Everybody got that? Yes.
You have to do this through a lawyer?
No.
Living will?
The living will, no. I mean, you can, but you don't have to. That's why I'm saying you could go to the
We just
Florida
fill out the
Bar
paperwork.
and fill out the paperwork. Okay. So when we talk about powers of attorney and healthcare surrogate, you have to make a decision. Who do I want to be my power of attorney? Who do I want to be my healthcare surrogate? Do I want my son? Do I want my daughter? Do I want my neighbor? Who do I want? And I always encourage my clients, think this through. And I share the story, it may be you want the same person, but it may be, in my case, for example, I have a daughter that is a physician, what do you call it? PA, thank you, yeah. Shame on dad. She's a PA and has a big heart and has, gone to Guatemala and worked in all these clinics. I want her to be my healthcare surrogate. My son, on the other hand, he's just business. He is all business. And if I had him, I want him to be my financial power of attorney. If I were to have him be my healthcare surrogate, he'd be like, Dad, I've run the numbers, I'm sorry. Gotta pull the plug. It just doesn't make sense. So you get the point that you want to think it through, and it's your decision to make. So make the right decision. Questions about any of those documents so far?
What if they're out of state? The son or the daughter, doesn't make a difference?
Doesn't make any difference. It only logistically would they have the ability to get down here or to direct from where they are. I've got plenty of clients that have people that have healthcare surrogates that are out of state. Sometimes they have to come down to do that. And then the last document to round out the batch that I think everybody should have is a blanket HIPAA. A blanket HIPAA. Now, everybody knows what HIPAA is because every time we go to the doctor's office, they make us sign HIPAA, right? It's our protected health information and nobody can have it unless we say that they can have it and so forth and so on. The reason that I've learned over the years this is so important to have a blanket HIPAA. You may say, okay, well, I've got in my healthcare surrogate can get my records. But what if my healthcare surrogate is unavailable? What if my healthcare surrogate's taken a trip to Sweden and I end up in a rehab facility for whatever reason, or I end up in the hospital? What I've seen is a very well-meaning neighbor or friend who's been just taking care of you all along is going and they're seeing the facility is denying you care. They're not turning you. I've seen people get bed sores and they're going in and they're saying, you need to do this. You need to take better care. And the facilities, what they do, and it's rotten, is they say, I'm sorry, get out. You don't have a HIPAA. We can't talk to you. So I have all my clients sign a blanket HIPAA, and I say, you put everyone in the world you can think of on there. So in the event that you're in that position, you always have a document that you can show them, and they can't deny at that point.
So you just list everybody?
Everybody. I mean,
And that's good no matter what state you're in?
I'm talking about for Florida purposes. I'm not an attorney in other jurisdictions, so I can't tell you.
But if you're not a Florida resident, do you have access to all these Florida, like, things?
Yeah, if you're not Florida residents, absolutely, you do. But what part, are you telling me you're here part of the year and they're part of the year?
Yes.
So what, my
Which is
client,
most of us, right?
Yes.
No?
yeah, so the thing, that most of my clients that are splitting time do both. They have powers of attorney down here and up there.
So one doesn't override the other? Depends on what state you're in?
It depends on what state you're in.
So if I understand you correctly, the only reason to have a power of attorney in Florida is to access government assistance.
No,
Okay, then I'm not correct, then help me out. Because I have a power of attorney in Massachusetts, I have everything up there.
mhm,
So
okay.
why do I need one here then if I'm not a
Or
Florida?
you may not, I don't know. But powers of attorney in Florida, we have what's called superpowers. And we have a list of things. So if you had somebody here and you were in Florida and you needed them and you had bank accounts in Florida.
I don't, 0.
Okay. And so if you don't have bank accounts in Florida and you have nothing here other than government benefits in your case, is all your property up north?
No, I have property here,
You
but it's
have,
not my primary residence.
okay. And so,
Sorry, I don't mean to
I
take
understand.
everyone's
Yeah,
time.
that's
Just
fair.
because they're
Situation, we'll have to all.
to make this, to help figure this piece out.
Sure.
actually.
sure. So let's talk about, and here we're gonna get into it. Let's talk about the property you have here, and do you have a will up north?
Yes,
And so it's not a trust?
no, we haven't done a trust yet.
Okay.
We're trying to decide whether we want Florida residents or Massachusetts residents.
All right, so,
or-
okay, so now I'm gonna start answering these questions as they're coming up.
So that's a whole nother meeting.
Let's talk about wills and trusts. And then this is gonna answer your questions on this.
Okay.
Okay, so when we talk about wills, everybody knows what a will is. You've seen it in the movies. You know, you write the will, and when I die, I want this person to have this. That's different than a trust. And the biggest difference between wills and trusts is wills are probated. They have to go through probate. Okay, which means that you have to go to court in Florida. If you have Florida property, which you do, you have to have a personal representative who has to be under Florida law represented by an attorney, which is another cost. And the personal representative then has to make all the inquiries. Are there any outstanding debts? Pay the debts and all this. And there's lots of costs associated with that. And time. You get around that if you have a trust. Because now what you're gonna do is you have a will here, you got a will up there, you have two probates. So you got double costs, right? So if you do a trust, you put everything into the trust and it passes without probate. Because when we have trusts, there's no probate.
So do I do a trust here or there?
You can do it, where is the bulk of your stuff?
Isn't it-
Moving.
If you do it, like, we're from Jersey, so we're looking to do a trust.
Right.
We're told, like, our lawyer would have to hire a lawyer in Florida to do it. So you could come here and get your lawyer in Florida.
Right,
So that's how that works.
that's exactly how that works.
We looked into it too. Same thing for us in Massachusetts to do with your, you pay Massachusetts, pay Florida.
All right.
Exactly, same thing.
Yes. So that's your answer with the trust. So, and for everybody's, that didn't follow along, if there's anyone that didn't follow along. When you make a trust, the property, everything that's in the trust passes outside of probate. You die, it just goes, okay? It just goes. So some of my clients that have changed residency, they come down here, they're here, they say they got rid of their property up there, they're all down here. The big difference for them is, do I want to pay for a will or do I want to pay for a trust? Because the trust is more expensive than the will. And I've just really seen it over the years. Some people think, well, I want to make it as easy as I can for my relatives, and so I'll put it in the trust. And the other half of the people think, I'm dead, I don't care, they can deal with it. And I'll save the money and do it the cheaper way. So that's a decision you can make, but that's the benefit of doing a trust, is so you don't have separate probates.
So the question still occurs, do you do a trust in Florida if you're not a Florida resident? Or do you do a trust up north, wherever everybody else is from?
Yeah, so it's really going to depend on, to me, how much time are you spending here? Where's your primary residence? And you gentleman from New Jersey.
Yes.
Your primary residence is New Jersey.
Yeah, I'm not down here full time, we're back and
Are you planning on coming back down here?
forth. One of these days.
Right.
But I was told that, my attorney up north told me you need a trust in Florida. If not, if one of us is passed, you have to go through probate, all this other stuff. If you have a trust, it eliminates all that.
Yeah.
So he was gonna do a trust for us, but then he said he had to hire a lawyer in Florida, so what I need you for, I'll get a lawyer in Florida.
Right.
Basically, but,
Listen, I'm from Jersey too, and we have an attorney that's licensed in Jersey, New York, and
Okay.
Florida.
Wow.
So are you okay?
So there are guys out there, I'm not trying to take word from you, but
No, that's fine.
there are people out there that are licensed in multiple states that can do this and give you the right direction.
So the direction is, you could do a trust in Florida, and I could put any property in the country. I can put Texas in it, I can put New Jersey in it.
Easy answer.
It doesn't
That was
matter.
easy answer.
That's the easy answer. I'm always cautious that I didn't want to offend, the attorney or whatever it is, but that's the easy answer.
Still, if you don't have that lawyer that's licensed in both states that you reside, and your principal residence is up north, I'm Michigan, I have a trust.
Mhm.
Do I need to have some other document to cover my trust when I'm down here in Florida, just residing for 5 months?
No. I would only say in abundance of caution, the healthcare surrogate and power of attorney.
Healthcare surrogate,
Yes.
but I have power of attorney in my trust.
You do for the trust, but if something happens down here to you,
Okay, so.
and you
probably
need
those
somebody down
things,
here,
yeah.
yes.
And then just FYI, these folks, if your trust is up north, you have to take your property here, and you need a quit claim deed to then be added to your trust. So like your condo or residence down here, you need to get a quit claim deed or a lawyer. And then your other state up north, can put that in your trust.
Right, and I walk my clients through that when we
Yeah,
do
you
that.
gotta have that.
You have to do what's called funding the trust. You can, it's not just making a trust, but you have to fund the trust. You have to put the property into it. And that's a different process.
So, one thing is, you just put property down here in the trust, leave everything else in the world.
Yeah, you could do that.
So you can't do that.
Yeah, yes, you can do that. You can put whatever you want in the trust, as little or as much as you want into the trust. I want to mention this to everybody, because this is one that many attorneys miss. So listen to this. If any of you have children, grandchildren that are special needs children, children with disabilities, be very careful when you leave money to them. Because if they're on benefits, SSI, Social Security Disability, or Medicaid. There's asset limits of $2,000. So if you leave, I want to leave $30,000, for example, to my disabled grandchild. When you do that, it kicks them off
Oh,
the Medicaid. Many attorneys miss this. Watch for it. So if any of you have that situation, watch for it. And there's workarounds. And that's one thing that we do have in Florida that you don't have in New Jersey, is we have what's called, well, you have elective share, where the wife or the spouse gets a third of the estate in Florida. All right, they can take a third or whatever's left. We can in Florida, which you can't up north, if you have a disabled spouse, we can take that elective share, and if that disabled spouse is getting disability benefits because she's disabled, if they took that elective share up north, it's going to kick them off their disability benefits because they now have more than $2,000. We can in Florida put it into what's called a special needs trust. So we have this little mechanism called elective share bypass passover will that we have. So if any of you have that situation, disability is one I always mention because it's one that people just don't think about. And another one that people don't think about, and I shouldn't laugh about this one, but and it's not funny in many instances, is check your beneficiary designations. So your life insurance, whoever you have, I can't tell you when I got the second wife coming in and the husband passed away and the first wife got $1 million life insurance policy because they never changed the designation to the second wife. And she's furious. There's nothing you can do about it.
The trust doesn't override that.
No. So check your beneficiary designations on everything.
Really?
IRAs.
But you can have those documents refer to the will, okay?
Yeah.
And such that, this is my understanding, that beneficiary named in the will also doesn't have to be named, they don't have to make a decision for 90 days. So they can have a cascading beneficiary. If they're disabled, their power of attorney can move to someone else. This is my understanding.
Yeah, but the beneficiary, as a general rule, the beneficiary designation in the policy is going to override your trust or your will.
Unless the policy.
That's why I said as a general rule. As a general rule, and like, you never see that. But I mean, you do, like one in, yes, sir.
So when you say that, my question. So when you say that a trust is more expensive to set up than a will,
Yeah.
what are we talking here? Like, give me like ballpark. Like
I can't
how much-
ballpark it. I can't ballpark
let's-
until I
let's
look at
say
your
it's
assets.
$1 million trust.
Yeah, and I have to see what you want to do with the trust.
Okay, the part B is, so I lump my property here and my property in Connecticut, and I put them all in the trust.
Right.
And I decide to sell it there. So how difficult is it to update the trust, and what are we talking about? Is it complex to get rid of that property, and now,
So,
because now my assets are different?
Again, that goes to how we're going to set the trust up and what powers are there in the trust that are going to allow to sell the property or not sell the property. Right? That's part of it. So if I'm hearing you correctly, you have property in Connecticut, you want to put it in the trust down here.
Yeah.
And then you're saying, but at some point in the future, I may
sell
want to
it.
sell part of that property.
Yeah.
Right. And that's not going to be an issue if you set it up the right way in the trust. And by the way, there are other things that you can do in the trust to, and this is a very good example here, if you've got a child that may have, many times, you've got two really good children and then a third one who's got maybe a drug dependency habit. And you can put certain qualifications in the trust saying maybe I don't want to give it all to him at once. Or I've even had people ask me, and I've made conditioned on they get drug testing, you know. So there's all sorts of things that you can do within the trust. So to your question about, there's lots we can do in a trust. But getting back to the beneficiary definition, the other thing is, does anyone have any transfer on deaths, TODs? Yeah. So most of those TODs don't allow for contingent beneficiaries, which means that if the person, and I've had this one too, if the person that you set up is the beneficiary, and the transfer on death means when you die, I've got a bank account, I've got $100,000 in it, and I do this form with the bank, and I swear to it and do everything, and I sign it and date it and all, and notarize it. When I die, I want it to go to Ted, because he's got my name. Right? But Ted predeceases me. And I don't have a will. Now, it's not going to go to where I want. It's going to go and pass through what's called intestacy. And these are certain laws that are set up in Florida. And the way that things pass when you don't have a will in Florida. A good example of this one, saw a case recently, I had a case recently, where there was a fella and he had a nephew, and his sister took care of him, and he was very, very ill. And he had 2 children that just took money from him and went on trips to Europe and never took care of him during his illness. And he passed away before, and then the family came to me after, before he was able to transfer through any type of will. He wanted to give it to the nephew, and he wanted to give it to the sister, all his property. And they told me he wanted to put it in the will, and he had all these affidavits and everything else, but he never got around to making the will. He died, and now because there was no will, it passed through what's called intestacy. And the first line in intestacy is the 2 greedy kids that were in Europe, and they took everything. So just think about that if you have any transfer on deaths, if you're doing any transfer on deaths, because that's one way, that's a way to avoid probate, and it's good in some circumstances. But always check your beneficiary designations and always keep up to date if you have TODs that the person's living that's on your TOD. All right. Other questions? How are we doing on time? Am I running out? No? Got plenty of time. Yes.
Do they have a sunset date on them?
They're open-ended. They're open-ended.
If I am a resident of Florida and have my trust set up here, but the person inheriting the money in the state is in a state where there's an inheritance tax.
I'm not a tax guy. Yeah.
Of the whole.
But, and it's not probated, so how are they gonna find out? I am not suggesting that you break the rules. I'm just asking kind of a rhetorical question.
I thought the inheritance tax is on you where you're the resident, not on where the person inheriting is. So for example, if you're a Florida resident, you die in Florida, is Florida have an inheritance tax? I didn't know. The state tax?
Yeah, so we've got inheritance tax and we have state taxes. I'm not a tax specialist, I got tax guys. Maybe I should have brought one of my tax guys. But we got the federal one. Yeah, next time we'll bring the tax guy. We got the federal one, which you know the big exemption on it, and then there's state ones. and estate taxes, and that is on the estate itself. Then we have inheritance tax, and that is for the individual who is inheriting. And I'm not a New Jersey guy, but I think you got different classes up there. Depending on what class you're in, you get taxed at, 11%, 16%.
I'm
whatever
from
it
New
is.
Jersey too, so I understand.
Yeah.
So could you talk a little bit about homesteading and being a Florida resident as far as it goes to trust and estates? Because I've heard that's an important thing to do and it helps with the estates.
Yes.
So maybe I'm wrong.
No, and where you go to get your homestead exemption is right up there. I direct you exactly to the site.
But if I'm not a
So-
Florida resident, I can't homestead.
You've got to, you gotta be.
Correct. Okay,
Yeah,
so
so
what's
that-
the benefit then as far as an estate goes, being a Florida resident and homestead versus just doing an estate in Florida without homesteading?
You ask really good questions.
Well, this is
So,
not my first time.
Just the
around.
two of you?
So.
it's not your first rodeo. Okay, so let's talk about homestead in Florida. So homestead in Florida, and I really heard it defined well one time. The idea of the homestead in Florida was that when my daddy in days gone by would get drunk and go down to the saloon, he couldn't gamble away the home.
Almost right here.
Okay, so we have these protections for our homes in Florida called homestead. And husband and wives, when you make this designation, husband and wives share equally. And they own it by tenancy by the entirety. And so it cannot be taken away. And like I was saying earlier in the conversation, if a husband or a wife wanted to devise part of it, they can't do it without a jointer agreement from the other. The other has to sign off on it. So we believe that much, that property is our property. All right. So for homestead purposes, that's what we mean when we talk about homestead. Your question is, if we have a homestead, and we put it into a trust, and you want to know what is the benefit to a homestead and a trust?
No, so it doesn't matter if I'm a Florida resident or not, a homestead trust is going to do the same thing for me, either way,
If you put your home into a trust,
yes.
that's, okay, there's a long answer, and it's longer
That's all right,
to.
all right. I don't want to hold everything, so.
Is there a tax benefit for homesteading?
Yeah.
And you lose that tax benefit if you hold the property in the trust, or is it still available?
It's still available to you, if you have a grantor trust, it's still available to you.
You can only file for a homestead during certain months of the year.
Yeah, and it's all here in the document, exactly where to go and where to file for it, and
And that's where we are doing it right now.
It is right now, yeah.
so, yeah, so if any of you are looking to establish residency, really grab one of these and start thinking about over the coming period of time between now and when you want to establish residency, so that New Jersey is not going to tax you later. You follow along to this and then get advice from your attorney up north too.
In a future seminar, is someone going to talk about maybe the benefits of becoming a Florida resident versus your up north resident? I mean, I know it has to do with like the value of your home, right? You should homestead the home that has more value, more taxes, right? But is anyone going to speak to like the benefits of becoming a Florida resident other than homestead?
Well, so I mean, we touched on some of the benefits, and really, we don't have inheritance tax, we don't have estate tax. Those are your big benefits.
No income tax.
There's no state income tax. So if you have a lot of money in a trust, your up north jurisdictions may be taxing income from that trust, that trust makes. Whereas we don't have that here in Florida. So we don't have the state income tax, we don't have the inheritance tax, we don't have the estate tax.
What about pensions? Do they tax that?
Pre or post?
Again, I can't, I'm sorry, I can't answer that one, honestly. I mean, there's no, yeah,
Doesn't matter.
but, I mean, but for federal purposes,
Yeah, they will.
that's what I'm, yeah, they tax.
State tax law,
Right.
federal tax.
As far as some of the benefits of being a Florida resident, I have no idea if this is true or not, but I think I heard something in the news that the Florida state legislature is talking about possibly doing away with property taxes and having a consumption tax.
Don't know. Yeah, I read it after they do it. It's not a lot.
Your husband, your wife, you both have to do it. Say we're in New Jersey and I want to make myself a resident down here.
Yeah.
We both have to be residents or can we split it?
Nice try. No, great thinking, great thinking.
Trying to get away from it for 6 months.
To get out from here.
You don't have to do it. Like more information about it.
Okay, sure.
How much that happen?
There's
Some options.
So, trust is a document. Right, there's two types of trusts. So a trust is a document that it's like a legal entity, person that holds property, bank accounts, whatever you want with tangible assets. So you take and you create this document, and you say, I'm going to give into the trust these different things, and the trust is going to hold and have ownership of these. Okay? So there's two types of trust. There's one that's revocable and there's one that's irrevocable. So for revocable trust, it's like it sounds, you can revoke it anytime you want. Irrevocable, that's what it means. It's not to be revoked. You can unwind it. But the biggest benefit to that is really when it comes to Medicaid planning. And Medicaid planning is when you have a husband and a wife in a situation where one has to go in the nursing home. And they see it's going to cost $12,000 a month. And they've got maybe $500,000 in assets. And they see, how are we going to pay for this? And Medicaid is a program that allows for that. But Medicaid says you can only have $2,000 in assets. And they say, we've got 500,000. What do we do? If you had an irrevocable trust for 5 years, this is just one technique, and you put all those at $500,000 in it, if it's irrevocable and it's for 5 years, the government doesn't count it. So they see you as zero, so you would qualify, and then that would be the benefit to an irrevocable trust.
Why do they make you hold it 5 years?
That's the state rule for Medicaid.
Nobody living here is gonna qualify for Medicaid. You know,
Yeah, well,
we have assets, we're residents here.
But if you set it up like that, you could qualify for it.
Yeah, there's lots of things you can do to move your assets around so that you would qualify. I hear what you're saying. Unqualified people with $1 million too. Only because they've got maybe a wife that's 60 years old and she's gonna be in a nursing home, it costs $12,000 a month for maybe 30 years. So in that instance, you have to come up with, but I hear what you're saying.
So what happens when you pass away then with that trust? Like, what happens?
So what happens when you pass away with the trust, whoever that you designate in the trust, I want this person to be a beneficiary. I want John to have this bank account. I want Sally to have this property. I want whatever you want, my rifle, to go to this person. Then when they pass away, when we pass away, they would just take a death certificate. And they would go to maybe the bank and say, here's the death certificate, here's the trust, and then they would take.
You can withdraw the money.
You can withdraw the money.
If I have 4 kids and I want it to go to them, but I want my husband to be able to live for the rest of his life without taking all the money to his new wife? Is there such an animal? But I wanted to be able to live, but not spend the whole thing.
Right, well, how much you want to give them?
Well, I wanted to be able to be comfortable.
That's kind of what they have to talk about. It'd be something you'd have to negotiate either way.
Yeah, and, okay, so what you would do first, you say, how much do I want to give to each of the kids? Easy. But then you have to look at, if it's in Florida, he gets a forced elective share, which means if you wanted 3/4 of it to go to your kids, it's not, he gets a third at a minimum. You guys got interim clauses, or no contest clauses in other states, which means you can't contest what we put into the will, and there are not elective shares in some other states. So it may not happen that way in other states, but in Florida, this is how it works. So he gets the elective share.
What if both spouses agree before?
Doesn't matter.
You can't put that in?
You can put it in, but the law is the elective share, and that's what he gets. So,
If it was
yeah,
a
so you
premarital
can't
asset.
contract it against the law. You can't contract to break the law. That's,
But if we both agree that this is how we want it, we're not, I mean,
I know, but
we
that's,
can't do, I think that's what we have set up in Ohio.
well, in Ohio, that's what I'm
Yeah.
saying, it's different in different places. But in Florida, we say we're gonna have a forced elective share, so that you can't get so mad and say, he gets nothing. Right? So that's the first thing. There's a question in the back?
I know that you mentioned earlier that you can't give a figure on how much it would cost to develop a will or a trust, but is there a minimum? Like if I go out and I speak to a lawyer and he says, I can do this for $500, should I be, a little bit concerned about what he's charging me?
You should be concerned. You're talking
So
$5,000
is
to
there a
$10,000,
minimum?
$5,000 to $10,000 to do it right.